For my legal philosophy assignment, I decided to research St. Thomas Aquinas as my natural law philosopher and Thomas Hobbes as my positive law philosopher. Thomas Aquinas is a philosopher from the 13th century and Thomas Hobbes is a philosopher from the 17th century. Aquinas combined the Christian idea of God with Aristotle's thinking about reason, happiness, and virtue. On the other hand, Hobbes was very influenced by some of the events that took place during his lifetime, such as the unsettling governmental changes occurring around him, as well as conflicting tasks that led to a civil war in the 1640s and ended with the decapitation of the king. Now moving on to natural law, which is an unwritten law code that governs the natural and social orders and represents the law as it might be in its ideal form. Developed by Aristotle, the concept was adopted by medieval European thinkers, such as Thomas Aquinas, who used it to refer to the law of God. And then there is positive law, which are written rules created by human beings that are enforced by the state. To begin, St. Thomas Aquinas was a 13th century Italian Dominican priest, or otherwise known as a monk of the Catholic Church. He held a position in the Catholic Church that led him to be the leader for those studying the priesthood. He was also a philosopher who held an immeasurable persuasive stance above many. However, the impact on the Western world that Aquinas was thought to have was extensive, and much of modern philosophy was envisioned as a response against or as an agreement with his ideas, particularly in the areas of ethics, metaphysics, political theory, and natural law. He described natural law as the eternal law that governs people's actions. He believed that it was the beginning of morality, ethics, and political behavior as it directs people toward their achievable goal of happiness. He said that natural law could also be understood through reason and conscience. In addition, St. Thomas Aquinas implemented his views of natural law from Aristotle in order to support the authority of the Roman Catholic Church in political as well as religious matters. This view required that natural law was a force of nature that is realistic and persistent. Aquinas also maintained that natural law governs both the natural and the social orders of society. Aquinas also acquired that God's natural law was willfully created to aid morality. He was very intrigued by how God's laws could apply in the secular world and what kind of relationship should exist between the Roman Catholic Church and the state. From this, Thomas was able to conclude that state laws should appeal to the godly ideal of just. If laws are unjust, however, he said, they breach natural law, which illustrates people from their duty to obey them. To St. Thomas Aquinas, the role of the state was to encourage the common good, while the main duty of the Church was to attend to people's spiritual needs. Finally, he argued the state was inferior to the Church because natural law, which the Church addresses as superior to laws created by humans. Now moving on to my positive law philosopher, that is Thomas Hobbes. Thomas Hobbes was one of the founders of modern political philosophy. Hobbes was an English philosopher in the 17th century who believed that nothing validated mutiny against the state. He also possessed the idea that positive law needs to be fulfilled to effectively uphold peace and order in a society. He expressed little faith in the capability of humans to make moral decisions and acquired that government and law exist to protect the rights and freedoms of individuals. From this, Thomas was able to conclude that human beings ultimately made up their societies. By creating their societies, Hobbes advocates that humans gave up their rights and freedoms for security by the government. Nonetheless, authority preserved sovereignty over the citizens and that citizens have to abide by these laws and rules. Finally, in today's day, individuals find Hobbes' theory fascinating, how law and stability are prominent to the miscarrying of rebellion and coexistence. Philosophers such as Thomas Hobbes recognized that in order for stability and order to return to England, there must be a new definition of law. This theory would eventually become known as positive law. Positive law is otherwise known as the belief that law is established by the state for the benefit of the state as a whole. Positive law has no moral purpose other than to ensure the survival of the state and its citizens. As a result, Hobbes became interested in the characteristics of a man, and what outcome this had on society. In order to maintain survival and self-preservation, people were required to surrender their natural rights to the sovereign. He believed that only the king should have the power to create laws, and therefore people would obey these laws, because refusing to do otherwise would mean a return to chaos and a state of eternal war. With this acquired information, Thomas Hobbes was able to conclude that the state of being was nothing more than a state of everlasting war, and man was a malicious, bestial, and aggressive being. He upheld that no rational authority would impose a course of action that could potentially harm their citizens. This is because the consequences would demoralize the power of the nation. In essence, Thomas Aquinas and Thomas Hobbes made an impeccable mark on the world, including their contributions to the natural law and positive law. Aquinas described natural law as the eternal law that governs people's actions. In contrast, Hobbes believed that nothing justified rebellion against the state, two very diverse perceptions that crafted both natural and positive law.